Welcome.
Доброе утро, дамы и господа.
About the WTO dispute settlement and sanctions. Let me first introduce our high-level panel to you. I think there's no need to introduce Maxim Medyakov. He is the architecture of the Russian accession to the WTO. And for him, WTO has become not only a permanent mission, but also a hobby. To my right, I have a colleague from the Russian private sector. He will provide you with his experience with international public law. Then we have on the right Alejandro Jara, former ambassador of Chile to the WTO and Deputy Director General with Pascal Lamy until last year. And now he starts to work as a lawyer in a law firm. And finally, we have from the WTO Secretariat, our friend Jorge. He is in the legal division in the WTO and directly involved in dispute settlement. Before we start this round, I may say that my name is Luzius Wasescha. I'm a former ambassador of Switzerland to the WTO, and I'm now chairing the diplomatic club in Geneva, which provides me an overview of the 30 international organizations which are active in Geneva. I have two preliminary remarks about the topic of today. First, the dispute settlement of the WTO is something unique. It started as a mechanism of conciliation, more a diplomatic procedure than a legal procedure, and it has evolved into a quite efficient system thanks to the trick of reaching not a positive consensus, but a negative consensus if the findings of a panel should be refused. And as there is always one which is winning, you never arrive to a negative consensus, and therefore you have a decision-making which is quite efficient. The second point I would like to make is the idea of the dispute settlement mechanism is to find back to the conformity of a measure, a national measure, with the WTO disciplines and the WTO rules. The sanction, which is possible at the end of the process, is therefore not a tool which strives to offend somebody, but it is a mechanism which should encourage, in all stages of the procedure, to find a solution. One could say, and I know it's exaggerated, the sanction in the WTO system is a little bit like an atomic bomb. You have it in order not to use it, but to have the pressure in order to find a solution. I hope in these next minutes we'll hear a certain number of illustrations of this, And of course, you will have the opportunity after the interventions of my panelists to ask questions or to comment. I would now pass the floor to Maxim Medyakov to present you the Russian understanding of the dispute settlement mechanism. Please, Maxim.
Thank you. Thank you, Mr. Luzius. You are right. Over the last few months, for the first time in our history, we have become users of the dispute settlement mechanism, and Russia is quite active in this process. Now, as you know, there are 3 procedures of dispute settlement in relation to the Russian Federation, and the Russian Federation has started 2 procedures. Measures applied by its trade partners do not comply with the obligations, so we are at an early stage, that is the stage of consultations, and so far none of the cases have gone over to the stage of considering the case and establishing a panel, which may happen in the near future. So, and I'd like to emphasize specifically that we are confident that the dispute settlement mechanism provides to Russia the possibility which we were deprived of in the former decade, that is, a possibility to have a fair solution to the problems using the agreements, WTO agreements, and complying with the obligations of the member states. Topics under discussion relates to sanctions, or the atomic A-bomb, which Mr. Luzius mentioned, and which quite recently was introduced by our trade partners. Oh, the sanctions rather, not the bomb. The sanctions introduced not in relation to the natural persons, because under WTO rules it is not applicable. But a number of countries, the United States and Canada, have introduced certain restrictive measures in relation to Russian companies. A number of Russian companies, and we believe that these measures go contrary to the obligations of these countries under the WTO rules, and that is why we requested to do away with these measures, restrictive measures. And there are 2 facts which are of importance. That is, our partners said at the meetings of the WTO bodies that they do not consider these restrictive measures contrary to their obligations. And we believe that this is a contradiction which is rather obvious, and we tried to show it to our partners, but our partners said no. But anyway, currently, we have a kind of a deadlock, because the Russian Federation believes that these measures should be done away with, and our partners believe that they comply with the WTO rules and regulations, but nobody makes any moves. The expert community believes that the trade restrictions which have been introduced against Russia may be explained by the provisions of the GATT agreement, GATT agreement, which allows countries to waiver from their obligations in cases of security requirements. And in the history of WTO, as our colleagues will tell you today, I hope, a lot of cases have occurred, incidents have occurred when the countries trying to justify their sanctions, they referred to the exceptions. Because they believe that they entitle them to introduce sanctions without complying with certain procedures whenever they believe necessary. That is, in those cases when the WTO member believes that the policy of a country threatens its security interests. And in his interpretation, the member state can introduce sanctions without requesting any permission for it, or without informing anybody of it. But there are the WTO members who stick to another approach, another opinion. They believe that this right to use or to apply sanctions in the interests of security is not absolute in nature. And in any case, certain tests should be applied, which are contained in the articles of WTO agreements, in particular in the GATT, or General Agreement on Trade and Tariffs. And there is a general article which implies that a member state can introduce measures to protect its security interests, but in certain cases only, for example, in case of war, or in case of serious aggravation of international relations. Thus, a question arises: what happened 3 months ago when the United States and Canada introduced sanctions? There was no war underway. We are not in a party to a war, and I hope that we will never become such. And was there any serious aggravation of international relations? Or not? Because our relations with the United States and Canada were deteriorating, but not like in the case of war or hostilities, because we maintain contacts, we maintain diplomatic relations, and thus we believe that the considerations of exceptions of general rules of WTO related to security interests are not applicable. But the question is, who is the judge? Who is the judge? Because there may be only dispute settlement procedure, which has been used by WTO for many times after the Second World War, and the WTO consideration of claims and complaints of a number of countries have been used, but it has never come to an end. That is, we have no end decision relating to interpretation of WTO provisions which entitle a country not to comply with the obligations. There are some special cases like this. The Russian Federation is now waiting for the outcome. We do not intend to pass over to some other actions because we are waiting for the outcome, but we are confident that the sanction regime, or the regime of sanctions, which is not related to violating WTO obligations, but is related to those things that are not regulated by WTO, that is, politics. So it's not applicable in this case, because the member states should not be entitled to take actions which go beyond regulation of trade or beyond trade regulation. And thus we will proceed from the fact that the restrictions introduced will be reversed sooner or later, and the WTO will continue to be isolated from politics at large. Thank you.
Thank you very much, Maxime. Let us dissipate any misunderstanding. We are not here a WTO panel who will assess whether or not the United States, Canada, or Russia has violated the WTO rules. Our role here is to explain the mechanism to you so that you understand more globally the functioning of this unique system of dispute settlement. I would like now to ask our colleague Jorge de Castro from the WTO Secretariat to give you an update of the dispute settlement system so that the background increases and we get confused at a higher level at the end of our session. Jorge, you have the floor.
Thank you very much, Mr. Chairman, and thanks to the organizers of the Legal Forum for inviting us to this event. As the Chairman was saying, maybe it would be useful to look at some of the background of how the WTO operates and what are the applicable rules for dispute settlement and more generally the applicable rules in the WTO. In fact, I brought some slides. Hopefully they could put them up so that we can follow the discussion. As of last week, the WTO has 160 members, with the exception of Yemen, which is the last country that has joined the WTO. That makes probably more than 98% of world trade covered by WTO rules. The WTO, when we compare it to other international organizations, has several characteristics. One of them is that all decisions in the WTO are generally taken by consensus, so there's no majority voting in the WTO, but all the bodies in the WTO generally adopt decisions by consensus. All WTO bodies are open to all 160 members. There are no bodies in the WTO with restricted membership, like, say, the Security Council in the United Nations. So all WTO bodies are open to 160 members. And the WTO, we still don't have the slides, but hopefully we can get them up at some point. And the work of the WTO, of the 160 members, is supported by a permanent secretariat, a staff of international servants. So I currently work in the WTO Secretariat based in Geneva. I'm part of this international staff that serves the work of the members. Now, legally speaking, the WTO, it's based on an international treaty, the Marrakesh Agreement, that established the WTO organization, the World Trade Organization, but that agreement itself is very short. It's only 16 articles, a very short agreement. And it's the constitution of the WTO, so it has all the constitutional frameworks, who can be a member, what are the main bodies, how are decisions adopted, how can the agreement be amended. But the substantive rules of the agreement are not there. So the substance of the rules in the WTO agreements are not in the Marrakesh Agreement, in the WTO agreement, but are rather in the annexes to the agreement. And there's annexes that cover, for example, detailed rules about trading goods, about trading services, intellectual property, etc. Within trading goods, anti-dumping rules, customs valuation, sanitary and phytosanitary measures, technical barriers to trade. So there's quite a detailed number of rules covering issues of trading goods, trading services, and intellectual property. In addition to those substantive rules, the WTO also has some institutional rules, procedural rules. So for example, Annex 2 is a dispute settlement understanding that contains details, rules, and procedures on how to help members resolve their trade disputes. Annex 3 of the WTO agreement contains a permanent mechanism for trade policy review, for the collective review of the trade policy of WTO members. And then Annex 4 is a basket for special agreements which are not applicable to all WTO members, but only to a few for WTO members which want to engage in further commitments, for example, in government procurement or other areas. In terms of what does the WTO do, what are the functions of the WTO? Basically, the WTO implements the current agreements that are in force, and when you come and visit us any day in Geneva, you'll see that there are plenty of meetings going on every day of specialized committees and councils which deal with the current agreement in force, customs valuation, anti-dumping, etc. So that's the domestic upkeep of the daily upkeep of the current agreements. Secondly, and here the WTO unfortunately has not lived up to the expectations that many members had, the WTO serves as a forum for further trade negotiations. And I say that unfortunately it hasn't lived up to the expectations because there has been a lot of ambition in terms of developing the rules, updating the rules, creating new rules, particularly since 2001, when the Doha round of negotiations was launched. But unfortunately, those negotiations are still ongoing. They haven't closed, except in very few areas, such as the agreement on trade facilitation that was reached late last year. So the WTO is supposed to be a permanent forum for trade negotiations. Thirdly, the WTO is there to help members resolve their trade disputes. And we'll talk a little bit about that in a few minutes, although Maxime already raised some of the main aspects of the system. And finally, the WTO more and more is exercising a role of monitoring trade policies. It's a collective forum for the monitoring of the trade policies of the members. So they exchange information about each other's trade policies, they raise questions, they raise concerns. Of course, in a detailed agreement, such as the WTO agreement, there are plenty of rules, and we cannot get into the specifics of those, but the basic rules of the WTO are probably the following. First of all, there's a general prohibition on trade restrictions. So by joining the WTO, members recognize that there's a positive element to international trade in terms of economic growth, development, creation of jobs, etc. So they commit to abstain from imposing trade restrictions on each other. And that's one of the first pillars or basic obligations throughout the system. Secondly, predictability. A very element in joining the WTO is the fact of having predictability on the rules which are applied to foreign trade. And so, for example, the WTO allows members to have certain trade measures. For example, tariffs. The WTO agreements allow members to keep tariffs as a way of protecting their domestic industries. But there has to be predictability. So tariffs cannot go over a certain level which is bound for every member and is the result of negotiations. So that trade is predictable, so that people know, exporters know what to expect when trying to go to a particular market. So predictability is a very big element, again, throughout the WTO agreements. The same as transparency. Throughout the WTO agreements, members commit to a transparent regime, trade policy regime. So there's plenty of notifications that must be provided. And the system serves also so that members can pose questions to each other about their trade regime. And finally, a very important pillar, legal pillar of the WTO system is non-discrimination. So rules should be applied in a non-discriminatory manner. There shouldn't be discrimination between the treatment accorded to domestic producers and to foreign producers in terms of taxes, in terms of regulations, etc. But also there shouldn't be discrimination between the way in which importers from different countries are treated. So again, non-discrimination is a very important obligation. Now, most of us in the room are probably lawyers, so we know that to every rule there's exceptions. And so it is with the WTO. So these basic obligations also have a number of exceptions. And the exceptions are spelled out in the agreement. There are no carte blanche, there are no blank checks, but there have to be special circumstances, special conditions for invoking these exceptions to the rules. And these are some of the many exceptions in the WTO agreement. So even though countries cannot charge more than a specified level of tariffs, there's anti-dumping measures. Even though they shouldn't discriminate, for example, there's regional integration, et cetera, et cetera. So each of these are examples of exceptions, but none of them are blank checks. All of them can only be imposed in particular circumstances and certain conditions. Now, some of the exceptions that have been cited, and Maxime has referred to one of those, are those contained in Articles 20 and 21 of the GATT. So, for example, Article 20 contains a list of general exceptions to the obligations in the GATT. And Article 21 contains a list of particular security exceptions to the obligations in the GATT. Each of them has different wording, Article 20 and 21, so it would be important to take that into account too. Now, general exceptions, those are not only in Article 20 of the GATT, because GATT applies only to trading goods, but they're also in the GATT's agreement, because they applied also to trading services, and even in the TRIPS agreement for some type of intellectual property rights. Security exceptions, again, they're not only in the GATT, Article 21, but they're also present in the GATTs with respect to services and in the TRIPS agreement with respect to some intellectual property right. Now, what you have to keep in mind is that these are exceptions to the rule. These are not the general rule. And mostly, they only become relevant if somebody in the context of dispute settlement challenges a particular measure, and this measure is found to be inconsistent with a general obligation, then the member that imposes the measure can invoke this exception. So, for example, if we're talking about Article 20, which allows the imposition of measures to protect plant life, phytosanitary measures, for example, it only becomes relevant if somebody challenges a particular phytosanitary measure, and that phytosanitary measure is found to be, say, discriminatory or a trade restriction that is not based on science, etc. At that point, the country that is imposing the measure can say, well, I'm invoking Article 20 as a defense because I think this measure is necessary for the protection of plant health. So let's look at it very quickly. Article 20 of the GATT has a general preamble, which is very important because it says these measures can be applied as long as they are not a means of arbitrary or unjustifiable discrimination, and these measures can only be applied if they're not a disguised restriction on trade. So these are the conditions to apply these measures. These are not, again, blank checks. These are not supposed to be disguised barriers to trade or means of discrimination. These are justified exceptions in particular cases. And then there's a list that Article 20 has of the type of measures that can be imposed by WTO members. So, for example, measures necessary to protect public morals or human, animal, or plant life or health, etc. So there's a whole list. And if any member considers that its measure is protected by Article 20, then it has to invoke this provision in the context of dispute settlement, if such is the case, and has to prove that the measure is actually necessary for the protection, say, of plant life, but in addition to that, that it is not applied as a disguised barrier to trade or as a means of arbitrary and unjustifiable discrimination. And there's plenty of jurisprudence. There are many, many panels that have looked at the exceptions of Article 20 and have interpreted the rules of Article 20. Now, in that respect, the situation is different with Article 21, because although Article 21 also comes from the text of GATT 1947, there's very little jurisprudence. There's practically very little jurisprudence that can be cited, because there haven't been disputes under Article 21. There has been no dispute in the times of the WTO and very limited disputes before the creation of the WTO in the old GATT. But Article 21 has a slightly different language than Article 20. It says again, nothing in this agreement shall be construed, and then there are different exceptions. One is about furnishing information, disclosing information which is contrary to essential security interests. That's one. Secondly, actions taken by a member which the member considers necessary for the protection of its essential security interests. And then there's 3 subparagraphs. One is about fissionable materials, so, I don't know, enriched plutonium, I don't know. Secondly, relating to traffic of arms, munitions, and implements of war. And thirdly, measures taken in time of war or other emergency in international relations. And the final exception has to do with collective trade sanctions imposed in the context of the UN Charter. So, for example, say at the time of the apartheid in South Africa, when the Security Council at the UN adopted trade sanctions on the South African regime at the time, well, those would be covered if a member complained, because those are adopted in the context of the UN Charter for Security. So there are slight differences, as you will note, in the language between Article 20 and 21. But the truth is there's very little to guide us at this point, because there hasn't been jurisprudence to interpret Article 21. So some final comments about dispute settlement, because Maxime gave a very good introduction. First of all, it helps members, the WTO system helps members solve their trade disputes. The idea is to preserve the rights and obligations under WTO agreements so that no unilateral action by one member upsets that balance of rights and obligations. Also to secure compliance with the WTO obligations and to clarify the provisions of the WTO agreements. And in that way, the system helps security and predictability in international trade. Now, the aim of the system, generally speaking, is to provide positive solutions to trade disputes. This is not an academic system. A member cannot go to the WTO system, a dispute settlement system, just to ask a theoretical question. This is really to solve practical trade disputes. And if possible, the system tries to achieve a mutually agreed solution between the parties, a solution that is compatible with their WTO rules. And when that is not possible, when it is not possible for parties through direct consultations to reach a mutually agreed solution, then there's the possibility of members to go to a panel of experts, to ask that panel of experts to issue a report. And if any of the parties disagrees with the legal conclusions of the panel, there's also the possibility of an appellate review, of an appeal. There's also, of course, the possibility of both parties agreeing to alternative means of trade resolution, but that rarely happens. One further note, the system is only for members, like Maxime just said. So only members can be complainants or respondents or third parties. There's no direct access for companies or individuals to the WTO dispute settlement system. The panel reports and the appellate body reports are ultimately adopted by the membership. So they become WTO reports. They're not just panel reports and appellate body reports. And from the moment in which they're adopted by the membership, they become binding to the parties to that particular dispute. One thing to note is that most disputes in the WTO are actually settled at a very early stage. They don't go through all the steps of the system. They're normally solved either at consultations or at a very early stage. And members are currently engaged in negotiations on how to try to develop and to strengthen the WTO dispute settlement. But I think it's fair to say that most members would agree that the system has been working reasonably well so far. The steps in the system, if parties cannot reach a mutually agreed solution early, are the following. They start with consultations. Then, if they can't reach a mutually agreed solution, they can go to a panel review, then the possibility of an appeal, and then there's a reasonable period for implementation. And finally, there is the possibility of what some people call trade sanctions at the end of the procedure, if the member has not complied with the results of the panel report or the appellate body report. But one thing to note is, under the WTO rules, there's a prohibition on unilateral trade sanctions against other members for violation of WTO rules. So only the WTO system can decide that there has been a WTO violation and authorize a member to impose so-called trade sanctions. Technically, they're called suspension of concessions. But the only way to reach that level when a member withdraws trade benefits from another member because of a WTO violation is by recourse to the WTO dispute settlement mechanism. I said before that most disputes are settled early. This is just to support that. We've had so far 481 disputes brought to the WTO. This is figures from this week, 481. Of those trade disputes, only 268 have gone to the second stage, which is panel review, so most of them have been solved in consultations or are still ongoing. Those, in turn, have led to only 186 panel reports being adopted and 125 appellate body reports. So as you see, more and more disputes get solved along the way. In fact, only 18 disputes in WTO history have gone through the A-bomb option of suspension of concessions. Only 18 out of 481. So that's, if my mathematics do not fail me, it's less than 4% of the disputes in the WTO have gone to the trade sanctions stage because a member has not complied in a reasonable period of time. Who are the main users of the system? That's probably predictable. The United States is a big complainant, and so is the EU, but they are also the main target for disputes in the WTO. The United States is the main target of disputes at the WTO, and secondly, the European Union. But then you see also a lot of developing countries which are very active users in the system. Maxime has also already said this, so I don't need to stop here, but since Russia acceded very recently, it's been a very active user of the system. It's already been the complainant in 2 cases, the respondent in 3 cases, and third party in 12 cases. And the idea that it's so active and it's a third party in many cases also gives you an indication of some of the interests, of some of the cases that have the interest of Russia. No? So 44% of the cases in which Russia is a third party have to do with the application of trade remedies, either anti-dumping, countervailing duties, or safeguards. And then there's other cases in which Russia is also a third party. Sorry, I think I took a few more minutes, but I thought it was interesting background information, and I thank you, and I thank the interpreters.
Thank you very much, Jorge, for this presentation. As a civil servant of the WTO, you have to justify that you traveled so far. Therefore, we accept that you were a little bit longer as foreseen. And I think you gave an overview which is useful for our discussion. I have now the pleasure to pass the floor to Christopher Ivanyan. He is in a law firm and will embody what you just heard into the general principles of public law or international public law. Please, Christopher.
Thank you, Your Excellency. I will switch into Russian, but before I will ask the gentleman there to switch on my presentation. Можно вас попросить включить презентацию? Спасибо.
Good morning. Thank you for this opportunity to talk about how sanctions are governed or regulated from the point of view of the international public law, not the WTO. And it would be very interesting to compare how these issues, disputes are solved in the public law perspective. First of all, I would like to dwell on those sanctions which are currently imposed against the Russian Federation or individuals of the Russian Federation, so that to facilitate the way of our discussion is developing. The US sanctions probably are the most consistent and expensive. They are they mean that the assets of those under sanctions and the assets which are controlled by the US entities are frozen, and these persons or individuals are prohibited from entering the US territory. Their visas are cancelled, and any attempts to circumvent the sanctions are legally prosecuted. And finally, all the subjects, US subjects or entities, are prohibited from having any contacts with these individuals or entities under sanctions. So sanctions are targeted not against individuals or legal persons, but rather against the Russian Federation. So these are sanctions in general are against the Russian Federation. So just to give you the idea of my presentation, I would like to dwell on this diagram. This, roughly speaking, provides the understanding how the sanctions are implemented under the public law, international public law. Number one, this is the obligatory measures in terms of implementing these sanctions. If international crimes are committed by the states under the sanctions. So by definition, sanctions are always the response with respect to the violation of international law. Sanctions are also illegal actions, and the only thing why those implementing sanctions are not legally prosecuted, or the state which is implementing this is not legally prosecuted, is that this is the response to the previous illegal actions or retaliation. These are so-called individual sanctions which are currently imposed against the Russian Federation by the United States, Canada, and Japan, and so on. Sometimes states decide to collectively implement or impose sanctions. These collective sanctions could be implemented in a limited, strictly limited number of cases. Mainly, when we are talking about the flagrant international law violations or imperative provisions of the international law. Then I would like to draw attention to the fact that besides the system of collective and individual sanctions, there is a system of sanctions which are implemented by the international organizations. First of all, the United Nations. The difference of this sanction is that they lack this element of illegal implementation, because they are implemented by international organizations, and by definition, by default, they are considered as legal. And those measures, even being illegal, these are the measures are of a peaceful nature. They do not entail the use of force, and each time we talk about sanctions, in the absence of military actions, we are talking about the peaceful sanctions. In order to legitimize the collective sanctions. So, collective sanctions could be implemented by the states which are not suffered because of the illegal actions of the respondent or state by under the sanctions. So if we are talking about the violation of imperative provisions of international law, like apartheid and others, or when the states who suffered are directly asking for implementation of these sanctions. Practically the same thing which happened in March this year, when Ukraine requested the imposition of sanctions against Russia. Terms and conditions of implementation of sanctions, in order to ensure the legitimacy of the sanctions and peaceful nature, besides the violations, is that they should be commensurate to the damage which was committed by this state under sanctions. This provision is also used by the WTO agreements in a different definition, of course, formulation, but this is the most important element in order to assess the legitimacy of the sanctions to be imposed. By definition, sanctions are of a temporary nature, and they should be such that after they are cancelled, the implications of the sanctions would be eliminated. So, depending on the sanctions that are currently imposed against Russia, so mean the measures which is the deprivation of the property assets of the companies and individuals. So their assets are frozen for the unlimited period, maybe for a month. So this is a creeping deprivation of the property from these entities and individuals. Just I would like to draw attention to the green arrow, which indicates the position taken by the international organizations with respect to the collective sanctions, because collective sanctions could be imposed in a limited number of cases, and that is why it is very important to determine whether they are supported by international organizations, for example, Security Council of the United Nations. If Security Councils, for various reasons, doesn't have a clear position on implementation of the sanctions, then the UN General Assembly and regional organizations should follow this. So, in the context of this assessment of the position of the international organizations with respect to the situation which could justify and legitimize the application of collective sanctions, could be that the only one universal document which can be applicable in terms of assessment of the situation in Ukraine and in the Crimea is the resolution of the General Assembly as of March 27. This resolution is quite often cited as an example that Russian Federation was blamed for violation of international law, but the resolution didn't mention this, despite the intervention of those states which implemented the sanctions against the Russian Federation. So there is no universal assessment of the violation by Russia of the principles of international law. This indicates the quite ambiguous situation in terms of the position of Russia and the position of Russia also merits some kind of consideration.
Also, I'd like to stress that though sanctions are directed against the state, actually they take the form of actions against certain individuals. And in this context, certain sanctions against individuals of the Russian citizens and foreign citizens alike automatically creates a source for damages, for losses of individuals that come under the sanctions and who is a, let's say, a foreign citizen of Finland, for example, and these sanctions, in any case, are a violation of the rights of Finland as a country, because the sanctions are introduced in relation to Finnish citizens without any relation to, well, situation in the Ukraine in terms of Finland. And so, I'd like to conclude saying the following. In terms of international regime of sanctions, the WTO regime is a kind of a special law, lex specialis, as is known in Latin, and the rights are regulated in the WTO as international responsibility, and the international public law may be used as subsidiary law if it does not conflict with the rules of WTO. And I think that these are well-developed rules and very specific international rules in terms of applying the responsibility of a state. And in terms of general responsibility, it may be only subsidiary. Thank you. Thank you.
The pleasure to listen to Alejandro Jara, who has a deep experience in the dispute settlement, and he will also react to what we have heard up to now. Alejandra, you have the floor.
Thank you very much, Luzius, and thanks to the organizers for inviting me. This is my second time in this legal forum. I came last year. There is a difference, though. Last year it was considerably warmer. And I mean the weather, not the political climate. I have some slides, if the gentleman can put it up there. That's the propaganda. That's the propaganda from my firm, King & Spalding. Thank you. And how do you do this? So I will make a few comments about the disputes in the WTO to give it some context. Also, like my friend, colleague from the WTO Secretariat. The first of all is that, as has been said, the WTO provides a lot of flexibility. Some call it policy space. And countries use that flexibility in order to apply measures. My comment here is countries have to be very careful how to use these exceptions, these flexibilities, because otherwise you get caught in and taken to the dispute settlement, you're going to lose a case. And that is politically not a wise thing to do for any government. So check before you do. Before you apply a measure, check with the lawyers, like us, like me, check with others, check with your with the agency in charge of WTO matters, and try to check the measure for WTO consistency. That is what we call achieve regulatory coherence. It is very good in many jurisdictions that the government, before applying any measure that is trade-related, will take it through the people who deal with WTO matters or with other trade agreements to check for consistency. And that will probably save hours of problems and will save hours of bilateral irritants between two or more countries. And I say this in particularly nowadays when I think that trade policy, generally speaking, has been evolving. As it was conceived before, a trade policy to protect the producer, more and more it's a trade policy to protect the consumer. So we go into measures that have to do with environment, measures have to do with labeling, with the marketing, etc., very intrusive. So you have to be doubly careful here about how you go up. So these are flexibilities. Use them wisely. Check before you do. It will spare any country a lot of time and trouble. In other words, the ideal situation is never having to go to the dispute settlement of the WTO. Another thing, the disputes, I want to raise here, comment. Way back in 1978, the European communities applied some restrictions on apples from Chile. I'm from Chile. I was involved in the case. I'm so old that I was involved in that case. And the measures were applied for a few months. But we took the European communities to the dispute settlement of the GATT because what we were seeking was a precedent. So the same measure would not be applied the next year and the following years. And it served the purpose. Chile won the case, won a very good precedent, and the communities felt constrained never to apply those measures again. So the market remained largely open. Secondly, some people say that bringing a dispute in the WTO is sort of creates political problems with your trading partners. I would venture to say that the opposite is true. For example, my country and the European community has had a long-standing quarrel about discriminatory taxes that Chile applied on the importation of spirits. And every time the authorities met, they would talk about this, amongst other things, in the agenda. And it was uncomfortable, it was an irritant, and it could not be solved until the European communities, tired, impatient, took Chile to a panel and won. And Chile had to remove the offending measure. But from the moment that Europe put that under the dispute settlement of the WTO, the item disappeared from the bilateral agenda. It was no longer a bilateral problem. Somebody else would solve it. So it's a gain to have recourse to the dispute settlement in political, in terms of your foreign relations. Further comment, there are measures which have been found to be in breach of WTO obligations, but for a party, it becomes politically impossible to comply. And that one, for example, is a case of the restriction or prohibition that Europe has on the importation of meat that comes from cattle that has been given hormones. They were found in breach, but the European Union found it impossible to change that because of the internal politics. What happened there is that at final analysis, somebody has to pay. The United States applied some retaliatory measures for some time until both parties reached an agreement allowing for more importation of beef from the United States that has not been fed with hormones. There are cases, therefore, which are unsolvable for political problems, but there will always be a price to be paid. And that has also to be kept in mind. And speaking of which, if a country has to apply sanctions or retaliation against another because the other party is not complying, you have to be smart about how to do it. You have to apply retaliatory measures, and you have to, in such a way that you build a constituency in the other party that will provide political support for that government to change the measure in order to bring compliance with the WTO obligations. Let me take two examples. Under a trade agreement, NAFTA, Mexico, Canada, United States, the United States did not comply with an obligation to let Mexican trucks cross the frontier and take goods across the border into United States territory. Purely protectionist. Finally, Mexico won a panel under NAFTA, and eventually, since there was no compliance, had the right to retaliate. Well, the Mexicans, very smart. They chose to apply restrictions on the imports of certain goods that came from about 35 to 40 states in the United States. So those innocent producers, exporters of the United States, all of a sudden face a problem of access to the Mexican market because there was this problem with trucks. So immediately they write to their Congress people, they write to their senators, they put pressure on the government to solve this because they are paying the price for another sector of the United States to be protected. That's what I call smart retaliation. Or for example, when the United States had to apply some retaliatory measures against the European Union, they chose a system which became known as the carousel. They would change the products on which they apply restrictions about every 6 months. So that created uncertainty in the market, and it increased the number of people who would put pressure in Brussels for those measures to be removed. Much has been said about the national security exception. I will have very little to add, except to say that to me, the national security exception in the WTO and the GATT and TRIPS is perhaps has a parallel with many constitutional regimes that provide for the ability of a government under certain circumstances to suspend certain constitutional rights like the right of assembly and others. So it's for very exceptional situations. I just want to recall that in the past, there have been attempts to justify under national security certain measures which are protectionist. So let me tell you two of these examples. Way back after the war, once the GATT was established, many European countries had problems of balance of payments, so they applied restrictions. During the 50s, those restrictions began to be removed, but a number of restrictions remained in place, and they could no longer justify those restrictions under balance of payments problems. So some countries had some restrictions and they chose to justify them under national security. One European country, for example, applied restrictions on the imports of boots because they claim that if in case of emergency, they needed to have a domestic supply of boots because the army uses boots. Yeah, but what about the boots of children? Anyway, and another country had restrictions on the importation of horses. And they also claim that this was needed in order to have a domestic supply of horses because they needed to move troops in case of an emergency. Well, they were subject to a lot of pressure from members who were examining all these restrictions, say, you cannot be serious to justify these measures under national security. So eventually those countries removed the restrictions because they felt that they could not, in all honesty, justify those protectionist measures under a purely national security argument. So there are limitations, but they're not written in the procedures. In fact, that there's just a consequence of peer pressure in some cases. Is the dispute settlement very expeditious or too lengthy? Why does it seem to take longer? This is of particular interest to the private sector, who is always affected by a measure and they want a speedy solution. Some would say that under international law, and including under domestic law, probably the dispute settlement of the WTO is one of the most effective and one of the most expeditious. But it has been taken longer and longer as time goes by. One main reason for this is that it has become very fact-intensive because of the nature of the cases that have been brought to dispute settlement, particularly around standards, around phytosanitary measures, around subsidies, etc. When you have to collect and bring to the attention of a panel of the appellate body massive amounts of facts, those take a long time to process and sometimes will even require that panels use experts in order to understand those facts, particularly when they are science-based facts. So it is in the nature of the system that as it has to deal with more complex cases, more fact-intensive cases, they will necessarily, and for good reasons, for due process reasons, take longer than one has been usually the case under the WTO. Mr. Jorge Castro alluded to negotiations underway in order to improve the dispute settlement. It doesn't need much improvement, but it can always be improved. I'd just like to say that there's also been some other exercises on which I participated while I was in the Secretariat to bring about procedures improvement without the need to change text. And that's a typical way of the trading system to evolve by trial and error, and first try out a measure before you codify it in writing. So there are also many practices out there which are not necessarily written, which can change and which can evolve to improve the system. My next point is about the end game. At the beginning, there's a process of bilateral consultations between two parties, and then the party does no solutions found, you go to a panel, you go to litigation. At the end of the day, when the outcome is there is a diplomatic negotiation again. Because here, one country has been found in breach, so it's up to the two countries, the complaining and the defending party, to discuss how long will the party in breach take to comply. And if they cannot agree, there's an arbitration procedure provided for. And secondly, if the country changes something, whether that compliance has been 100% or not, and whether it brings satisfaction or not to the problem. And here is where there is a diplomatic negotiation between the two parties, but based on a report by panel and or the appellate body that says that this measure is in breach of such an obligation of the WTO. So that also to be kept in mind, that at the end of the game, it resorts to a diplomatic negotiation based on a ruling that is based on WTO law. And one next to last point is always pick a winner. If one looks at the cases that are being brought to the attention of the dispute settlement system in the WTO, more often than not, the great majority of the cases, the complaints, are successful. This indicates that most governments are very careful about bringing cases to the WTO. They will only do so once they are convinced, and they have been very thorough in terms that they have a very good chance of winning the case. My firm, for example, we are involved in a case that Russia has against the EU on the calculation of anti-dumping, and so we are counsel for the industry of Russia, and I can testify that both the industry and the Russian government be very thorough in terms of being very careful about taking this case to the WTO, because there is this intellectual conviction that you have a right to protect, one, and two, that you stand a very good chance of winning the case in the WTO. I have seen in some countries sometimes bringing cases to the WTO in retaliation against cases brought against them. So usually if you think that a case brought against you, the other party will prevail. If you just bring a case in order to annoy or to retaliate against the other party, and you're not sure you're going to win, you're probably going to lose twice. And I think that is something which does not add to be a good politics. So you're losing at both ends, and that is something really to be discouraged, and is not a very good use of the dispute settlement of the WTO. That's why I say, when you move, always pick a winner. That's very important. And my last slide is to say thank you very, very much.
Thank you very much, Alejandro, for these insights. We come now to a broader discussion, and given the sensitivity of our Russian friends about sanctions, I think that we have to focus first on that. In the presentations, we have seen two cases. We have the dispute settlement system, which at the very end may allow one member to retaliate against the member which has not put in conformity his measure with the dispute settlement. The other question is, can you use the dispute settlement mechanism when you are exposed to a sanction? And here I think Maxime already hinted to that. If there is a relation with the WTO law, you may build a case. And the difficulty we face today is that whilst we have a huge experience with disputes in trade in goods, we have little experience with disputes in the area of services, and we have only the case of anti-dumping where a person or a firm is targeted. So this is the basic problem we face in the present discussion about sanctions. We have seen, thank Christopher, that other forums could bring the basis for governments to take sanctions against others for political reasons. I remember a negotiation where we were talking about these blood diamonds, where we had a basis in the UN, and in Article 21 of the GATT, we have a reference to measures taken by the UN. And it's not surprising that those negotiators who were coming from the UN, mainly the majors, they argued that only measures taken by the Council of Security are targeted by the dispute settlement mechanism by the Article 21, whilst others said, no, it's also decisions taken by the General Assembly. Of course, in one case you need consensus, in the other cases you need a majority. We are here in a very sensitive area, and the experience shows in WTO that when you manage to translate a political issue into a technical issue, the system works. But if the issue remains political, then the system of WTO cannot solve the case. It can bring arguments for different parties thanks to the system, but it cannot solve it. Who would like to come in with questions or comments about sanctions? Yes, sir.
Спасибо. Я, наверное, адресую...
Thank you. My question is to Mr. Ivanyan, if you don't mind. So my question is, so various sanctions, be it political or economic, exercise certain influence on economic subjects. Can we consider force majeure as something we can refer to? Because you mentioned the ban for future deals and transactions, but there are certain deals that have been concluded already. Can we refer to, in this case, to force majeure as far as current contracts are concerned? It concerns Greece, master and visa blocking actions. So this is not a single case. This is a kind of a regular thing that is occurring now. And predictability of WTO in economic sphere, it is lost. Certainly this is a matter of each particular agreement or contract, because domestic law has not got the international law translated into, as far as Russian law is concerned. I have some doubts whether this may be a basis for wavering responsibility when there are risks involved at the very beginning of the process. I think that most agreements which you have in mind are deals covered by Western law. That's why I cannot comment them. I don't know how it happens in English law or elsewhere. I believe that it depends to a great extent. Well, I'd rather put it like this. There's a more general question. to which extent the behavior or conduct of certain individuals under the sanctions may be related to certain international violations, legal violations certain states are accused of, because the sanctions in relation of the Russian Federation, there are two different groups of companies and individuals. There are individuals who are in a way within the Russian political circle or politicians, and at least take some top positions and are related to the developments. But there are a number of businessmen who have nothing to do with what's occurring in Ukraine or Crimea or elsewhere, and whatever the opinion is correct, well, they suffer, and the international rules, they do not provide any answer to the question whether they should be a standard or standards or rules for the conduct of these individuals in order to be related to the measures taken. Because I have the feeling that nobody applies the standard taking the measures, but we say that they are contrary to international law because there are a number of human rights laws and acts which envisage the right to have the property restrictions supported by court suits and considerations within certain procedures.
Should we talk about the European sanctions? There is such possibilities. I'm not aware of the Canadian system. With respect to the United States, then the choice of appeal is practically excluded. I have Elizabeth Ryan sitting in front of me. Maybe she could answer these questions with respect to the US law or US legislation.
Further comments or questions? Yes, sir. We come to you afterwards.
Yuri Botyuk, Pinsent Masons, London. The telling comment was turning things from the political to the technical, and that seems to be the answer in terms of getting one off the sanctions list, noting the very correct comment that there's many non-political people on the lists. And there's a remedy in the EU to take action in the EU courts, but they're very slow. But I would like to, from a completely practical point of view, ask the panel for their view from experience. When does the new normal take place? Right now, there's a lot of concern within doing business with Russia and Russians, which has caused Western companies not to engage in new business. But if the sanctions regime stabilizes, then, and it doesn't expand, then one would foresee that business would then start happening again. From past experience, when does the new normal come in and that business as usual, say for the people on the list, can start?
Thank you. Who volunteers from the panel? If nobody volunteers, I have to do it. That's my role as a chair. Well, usually the sanction is taken because something happened. If this is corrected, the sanctions can be removed. That's a very theoretical, candid answer of a lawyer. Maybe you will not pay him for this advice, but nevertheless, that's the only way I see how it could work. But you mentioned in a very smart way a background which we certainly can also address here. The problem of these firms you mentioned is not the law, it's the trust. And the law should help to build trust, but sometimes by a certain number of actions which are disapproved by others, this leads to a loss of trust and a loss of credibility. So again, we are not on the technical level, we are in a broader political space. Now, Adam, we come to you.
Господину Иваняну.
I have a question to Mr. Ivanyan. In your presentation, you said us about collective and individual sanctions. It's clear with respect to the collective sanctions. According to the international public law, does it provide for a possibility to impose individual sanctions? I would start from the end, because you actually asked several questions in one question. So maybe for about 25 years, the UN Commission on International Law have been engaged in codification of the rights and obligations of the states, and several drafts have been prepared which should lead to the adoption of the Convention of the international responsibility of the states. Now this work is at the completing stage. Just several years ago, several articles have been codified with respect to the responsibility of states, which codifies the international common law with respect to the use by one state against another states of sanctions, which in fact are not called sanctions under the public law. This term or definition is used for the institutional sanctions, but these measures could be applicable exclusively in response to the previous illegal acts by the state or a group of states. But it's clear that in the absence of a body, independent body, which besides the member states or the international community could decide what conduct is illegal and legal, so we always say that this is a factor in terms of application of sanctions is quite important. So the second important condition is the objective, why the sanctions or measures are made. They shouldn't be related to a sort of punishment. They should be applicable only to stop the violation and to urge the violator to rectify the situation which existed before the violation. There are some technical moments, but I don't think that it's time to stop on them, to dwell on them.
If there is no appetite for putting questions or making comments, I would like to invite the panelists to draw a short conclusion each from the different issues we have raised in this panel. And I would like to start again with Maxime.
Thank you very much, Luzius. My conclusion would be very simple, which is based on the outcome of today's discussion, and it is as follows. And my colleague Castro talked about this. If international common law, public law, the issue of sanctions is not regulated completely, and we so far don't know about the future, how it would be determined, that is, then the WTO legislation is more predictable in this sense, and it doesn't have any provisions which provides some kind of freedom or carte blanche to member states not to implement the obligations assumed. So far, we don't know how the dispute resolution procedure would be applied if a state or a member state would like to call in question some existing procedures. And and it was mentioned that the WTO hasn't so far accumulated enough jurisprudence in terms of deal with these issues, especially even taking into account the GATT agreement and long history of GATT agreement. But we have such prospects, and this is what we would like to proceed from in terms of our future actions. Thank you.
Thank you, Maxime. Alejandro.
Thank you. I think
Благодарю вас.
draw three very brief and very broad conclusions. One is dispute settlement of the WTO is a very powerful, it's a very effective instrument. It works, it levels the playing field, it protects all, particularly the weaker parties. Secondly, this tool, this instrument has to be used with care and has to be used in a very responsible way in order to lend credibility to the process, and also it's a procedure, it's a system which must be at all times protected by the members so that it becomes more and more effective at other times. And thirdly, I'd like also to draw the attention not only within the dispute settlement system, but outside of it, there are other ways and means in which countries can attempt to solve problems they may have. It is not only through the consultation phase of the dispute settlement, but also particularly using the bodies of the WTO, beginning with the General Council or the Ministerial Conference that meets every 2 years, or the subsidiary bodies that meet very regularly several times a year, where members bring forth their concerns about measures being applied by other members. They discuss these, they engage in a dialogue, they do what I would call an impact assessment. Your measure is affecting me in such a way that I am suffering injury in terms of my exports, my employment, et cetera, et cetera. So that is also provides an opportunity to seek support from other members who may have similar concerns, if only of a systemic nature at times. But the whole of the WTO at the end, not only its dispute settlement, can usefully serve the purpose of trying to solve particular concerns and problems that countries may face derived from measures that other countries apply. Thank you.
Thank you, Alejandro. Christopher?
Thank you. Несколько выводов. Во-первых,
Several conclusions. It's good that we managed to join WTO before sanctions imposed against us. Besides the international legal tools which are usually used in these cases, now we have also more tangible and more peaceful and which works very well, better than other mechanism in the public law, envisaged by the public law. Secondly, the WTO system, from my point of view, and from the point of view of its capability, capacity to solve disputes between states in a technical and business manner, it's a good example how the public law, by reducing the volume of, where possible, of course, political and ideological discrepancies between the states, but at the same time could allow us to reach some consensus and the prosperity in the final analysis.
Thank you, Mr. Chairman. And I think Christopher made
Благодарю вас. Христофор говорил о том, я также хотел...
taking place now. A few years ago, we wouldn't even have this discussion taking place. And it's only because Russia has now successfully acceded to the WTO that there are all these rules about predictability and rules of the game which apply and which provide a forum in which many of these things can be discussed and can be checked for consistency with international obligations. It is true that there are not many precedents in the invocation of Article 21, but also specifically on challenges to the invocation of Article 21. There's no panel reports that we can cite or appellate body reports that we can cite. But that's also the situation for many other trade disputes. We've had plenty of disputes in the last few years dealing with provisions that had never been tested under the WTO. So just the fact itself that Article 21 has not been tested doesn't mean that it may not be tested in the future, and it may not be, a particular measure may not be checked for consistency. But now, one of the things that there is at least now there's a framework of multilateral rules that applies to these kind of situations. And for example, in November 1982, during the crisis of the Malvinas Islands, Falkland Islands, when measures were taken against Argentina, Argentina brought this issue to the GATT, and a council decision was approved at the time about transparency in the imposition of measures which are invoked under the protection of Article 21. So there are some multilateral rules and constraints even to the ability of applying an exception such as Article 21. But it's good that we can now have this discussion again as a result of as a positive result, I think, of Russia joining the multilateral trading system. Thank you.
Thank you very much. I would just like to add a footnote. There's one element which has not been mentioned and which sometimes may play a role. If, as a government, I take a measure which is inconsistent with the WTO, I may do it just to satisfy my lobbyists, my constituencies. It's the same for sanctions. Sometimes governments don't expect these measures to have an effect, and they don't mind if they lose the case in the WTO. We have seen that with the Byrd Amendment, which was imposed on the government of the United States by the Congress, and all those who were responsible for WTO matters were very happy to have lost the case. Senator Byrd was less happy, but it was just a bird. Thank you very much for your attention, for following us in this debate, and hope we can continue that in a year's time with more experiences, more cases that have evolved in the WTO. Thank you very much.